guess if you don't see a cat on my screen, this is the right time to start. Dear friends, it's my great pleasure to welcome you to tonight's webinar, the ICC decision, where do we go from here? My name is Jonathan Heuberger, and I serve as Director for International Cooperation at Israel's Ministry of Strategic Affairs. I'm delighted to welcome all of our friends tonight from the GC4I, the Global Coalition for Israel, LNI, the Legal Network Initiative, and from Digital. Welcome also to all of our friends from the International Legal Forum, from near and far, and to our esteemed speakers. When I first studied international criminal law and about the ICC, this was rather an esoteric field at the law faculty. You were either a criminal lawyer or focusing on public international law and the relations between states. Some even predicted that this would be a field with, and I quote, zero professional future and only academic in nature with no practical relevance. Now, much has changed since then. The ICC and the Israeli-Palestinian conflict have recently made headlines, and we thought, together with the International Legal Forum, under the leadership of the wonderful Yifat Segal, to hold this webinar to update you on what has really happened and where we go from now. It is very important to emphasize that the ICC prosecutor has not yet opened an investigation into Israel. Rather, the majority of pre-trial Chamber 1 of the court has held that Palestine was a state party to the statute of the ICC, the Rome Statute, and that the scope of the court's territorial jurisdiction in the so-called situation in Palestine extends to, and I quote, Gaza, the West Bank, including East Jerusalem. The presiding judge over this chamber, Judge Kovac, dissented with this finding and presented his own conclusions, which sought to reduce the scope of the court's territorial jurisdiction and include stark criticism with some of the findings of the other judges. Last Friday's ruling came as a response to a request by the ICC prosecutor of December 2019, in which the prosecutor asked for confirmation by the court that she has jurisdiction over these territories. As you know, the State of Israel's position is that the ICC has no jurisdiction to deliberate the Palestinian case. Israel is not a party to the Rome Statute and has not consented to the court's jurisdiction. The Palestinian Authority is not a sovereign state that may delegate jurisdiction to the court as required by the statute. Therefore, the court manifestly lacks jurisdiction in this matter. All of these points have been presented in a very thorough memorandum published by Israel's Attorney General, and I invite you all to study it. Looking at the bigger picture, let me say that my personal belief is that it's very unfortunate that a court that has been established to confront mass atrocities that shake the conscience of humanity is going after democratic states with robust and independent legal systems. It is worthwhile to mention that different countries have already come forward against this legal development. Now, where does this leave us? This is the question we'd like to discuss tonight, and I'm delighted to quickly introduce all of our esteemed speakers before they'll take the floor. We have with us tonight Yifat Segal, founder and executive director of the International Legal Forum, Brigadier General in the Reserve Yossi Kuperwasser, senior project manager of the Jerusalem Center for Public Affairs and former director general of the Ministry of Strategic Affairs, Professor Eugene Kontorovich, director of the International Law Department at Kohelet Policy Forum, Anne Herzberg, legal advisor and UN representative for NGO Monitor, Maurice Hirsch, head of legal strategies for Palestinian Media Watch, Jonathan Turner, chief executive of UK Lawyers for Israel, and Joshua Kern, barrister at 9 Bedford Row, Judge Chambers of Stephen K. QC. We have referred to this event as an event by the network for the network. So we will hear 7 short presentations from our speakers, and then you'll be given the opportunity to ask questions. It's time to start. Yifa Segal, you will put the decision in context and say what it is all about. Thank you.
Well, thank you, Jonathan. And I would like to thank everyone for joining us today. This is an amazing panel. And we do have a lot of participants. As you said, we never imagined that we will be so popular just because of dealing with international criminal law. So thank you to everyone who took the time to join us today. So just to put the discussion in context, to give you an idea of what really happened last Friday in a few short sentences. So the decision came on Friday, on February 5th. And we were, let's say, waiting for a long time for this decision, although not really waiting. It was overdue months ago. And it came out eventually with a majority opinion of 2 judges and a dissenting 1 judge with a completely opposite opinion. The question, they basically had 2 questions that they had to answer. The first question was, is Palestine a state or a state for the purposes of the Rome Treaty? Why is that important? Because the Rome Treaty or the jurisdiction of the court, the jurisdiction of the ICC can only be applied to states. That's an inherent, a fundamental principle of the court, to a state, which is a state party to the ICC, and then only to alleged crimes that actually occurred within the territory of that state party. And so these are mainly these were the main questions that had to be answered by the court. And let's say that if the court came back to say, no, Palestine is not a state, no, it cannot, there is no clear territory for that state, and therefore we cannot apply our jurisdiction to it, that would have been the end of the story. And that would have meant that the ICC would not be able to look at alleged crimes that occurred in this context at all, at least not in this moment in time. Therefore, this is why these proceedings were so important. And so a lot of our speakers here, and I think a lot of the participants, a lot of experts in international law, many submissions were filed to the ICC to basically say there are fundamental rules of international law. You cannot change those rules. You cannot be flexible on that. There are ways to establish statehood. There are ways to establish the territory of states. And therefore, even if you are have let's say a sympathy to the Palestinian cause or a sympathy to one of the sides, this is not something that you can deviate from, and therefore the court should not have jurisdiction. And so as I said, many submissions were filed, including by 7 states, which we thought was very, very impressive. Those states included Germany, included Austria, Hungary. Many other states have also made statements about this. Unfortunately, just to give you the background, the majority opinion came back saying none of that matters. Palestine is a state party to the ICC, meaning that they have membership in the court. They basically based that on a technical issue of their acceptance as a party to the treaty. They've based that on the fact that the United Nations General Assembly and then also Security Council referred to Palestine or future Palestinian statehood, or referred to their right to have a state based mainly on their right to self-determination. Of course, said that would be somehow based on the 1967 lines, and that is the main issue that was discussed in the majority opinion. And this is what brings us here today, to understand the legal ramifications, to understand why this is, let's say, unorthodox, to say the least, what kind of other ramifications in terms of international law this decision might have, and what does it mean for us, and where do we go from here?
Thank you very much, Yifa, for these insights. Now it is my great pleasure to turn the floor to Yossi Kupavasa. You have published a study that is called The Legal Assault, How the ICC has been weaponized against the US and Israel. And there, now you will elaborate how anti-Israel NGOs and their delegitimization campaign contributed to this outcome. Kupa, the floor is yours.
Thank you, Jonathan. Thank you to all the my colleagues here, the participants and old friends. What I'm going to speak about is about this paper we published some time ago about the legal assault, and this focuses on the role of the NGOs in promoting this campaign against Israel in the ICC. So what we focused on, and I think this is important, especially for those of you that are Americans, is that the same group, the same groups and organizations that were involved, and the same people actually, that were involved in promoting a parallel complaint in the ICC that Bensouda is considering as well as in investigating, which is directed against US activities in Afghanistan, are the same people who are deeply involved in the complaint against Israel in the context of Palestine. And these are the same international organizations, both FIDH, FIDA, which is the Federation of International Human Rights, and the CCR, which stands for Center for Constitutional Rights. And these are organizations that are deeply involved in fighting against Israel and supporting BDS, and especially on the legal domain. But in this case, they were leading and tutoring the Palestinian NGOs in their way to the court. And as a matter of fact, the two ladies that represented the FIDA and the CCR in the complaint against the American activities in Afghanistan were the same ladies that were involved in the submissions of the Palestinian NGOs to the ICC. And our claim that this activity was a political activity, actually, and less legal activity, was, amongst other things, based on the fact that FIDA is closely related to Bensouda herself. And Bensouda is presented by FIDA as a close friend, and she participated in activities of FIDH along the last several years, including visiting FIDA in Paris and participating in a conference to the 40th conference of FIDA. Bensouda was there. Now, these organizations, of course, are totally committed to taking action against Israel. They support BDS anyhow. And those two ladies that support, that represent FIDA and the CCR, which are a Palestinian lady called Nada Kiswanson van Huyden, and another lady named Catherine Gallagher, are doing the same stuff simultaneously. As a matter of fact, Kiswanson was the representative of Al-Haq in The Hague, and she headed the office of Al-Haq, one of the four organizations, Palestinian organizations that led this activity in The Hague for a couple of years, and was involved in this respect in the activities of the submission of the complaints to Bensouda. As we all know, the four organizations, the four Palestinian organizations that are involved in this case are first and foremost Al-Haq, headed by Sha'wan Jabarin, the famous Sha'wan Jabarin, who is a former activist of PFLP and still remains closely affiliated with the PFLP, with the Palestinian Front for the Liberation of Palestine, a terror organization designated as such by many countries, including the United States. The Palestinian Center for Human Rights, PCHR. Al-Haq is located in Ramallah, in the West Bank. Al-Haq is in Ramallah. The PCHR is in Gaza. So are the El-Mizan and Damir, the two other groups that were part of this effort. All of them are closely related to the terror organizations, especially the PFLP, They have close ties with PFLP. Some of them are also, in one way or another, close to Hamas activists and keep good relations with Hamas. So these are not NGOs that are concerned with human rights. These are political activists that are part of a terror organization that is committed to the battle and to the ongoing struggle against Israel, against Zionism. And their role is to conduct the fight on the legal arena. And that's what we are actually witnessing in this campaign. Now, they managed to have the ear of Bensouda, and unfortunately, and that's how this report of Bensouda and her decision to investigate or to consider investigating was worked out, and how she eventually, together with the input of the Palestinian Authority, of course, these four organizations were part of the committee formed by Abu Mazen back in 2015 to promote the complaint to the ICC. And so together with the Palestinian Authority and with their international bodies, they promoted this complaint. Now, as the pre-chamber, the pre-trial chamber has made his opinion known, they are of course very happy, totally committed to take advantage of this decision in order to promote as soon as possible the opening of the investigation, and hopefully, and from their point of view, an arrest warrants to Israeli politicians, especially they are interested in politicians. Of course, officers are fine too, but they are interested in convincing Bensouda to take steps fast. They are afraid the time will elapse before anything is happening. And they announced that they believe they are able to present convincing evidence to support the decision to open the investigation as soon as possible. And this is what they are focusing on. Of course, I believe that they are going to keep working together with the PA on that issue, to be coordinated with them. And their role is not over yet. They celebrate the big achievement they had, but this is not the end of their activity. They are totally ready to keep working very intensively in order to make sure that this opportunity is not wasted.
Thank you, Yossi. I think we will stop at this point. Later have more rounds of questions. Now we will turn to some questions of international law. The ICC has not determined that Palestine was a state under international law, but only that it was to be considered as a state party to the ICC. And therefore, the judgment is very much limited to this specific finding with regard to the applicability of the Rome Statute in this area. However, having international court getting into these questions may be considered highly problematic. With us is Eugene Kontorovich, who will elaborate more on this. Eugene, the floor is yours.
Thank you. The ICC statute, the Rome Statute that creates the ICC, limits membership in the court to states. That is to say, countries. You need to be a country to join. As a result, there are many entities, national independence movements that would probably like to be part of the ICC, but in fact are not. So for example, Western Sahara, also known as the Sahrawi Arab Democratic Republic, recognized by some countries but not most, not a member of the ICC. Kosovo, not a member of the ICC. Generally, the only countries that are members of the ICC are countries that are universally recognized as states. And the Palestinians joining the ICC is the singular exception to the rule. They are the only members of the ICC where there is not just some, but massive international disagreement about whether they qualify as a state. Okay, now whether or not an entity is a country, is a state in international law is a legal question. It is a question of law. It's the first question of international law, because before you have international law, you need to know who the nations are. And as a result, determining what is a country and what is not a country is a basic question of international law. And there's a legal test for it. textbook legal test called the Montevideo criteria. It's a 4-part legal test. Now, whether or not the Palestinian Authority meets this test, the ICC did not even purport to apply the legal test of whether the Palestinian Authority is a state to see whether it qualifies as for membership. So let's review. The statute, the treaty, the constitution of the ICC says you need to be a state. Palestinians show up and say, we want to join. And the ICC admits them without conducting the legal analysis as to whether they qualify as a state. Now, what they say is the General Assembly voted in 2011 to call them a non-member state of the United Nations. So what's that mean? It should mean nothing for the ICC. Why? Because, of course, the General Assembly is a political entity. It can admit entities as members or not as non-members of the UN. It can call entities states without applying any legal test because they're not a court. They're not a legal body. They can vote whatever opinion they have as a political matter. They can vote, as indeed they did, that Zionism is racism. That does not establish it to be a legal fact. And it's important to say that the International Criminal Court is supposed to be an independent institution. It's supposed to not be like just an arm of the United Nations and just echoing the anti-democratic, anti-Israel, lowest common denominator consensus of the United Nations organizations. The ICJ, which is a non-criminal court, is actually a branch of the UN constitutionally. It's the judicial arm. The ICC, because it can put people in jail, is supposed to be independent. So when the ICC says, you know what, we're not even going to conduct a legal analysis on this point, we'll just say ditto to whatever the UN says, they're first of all failing to conduct a legal analysis, the first thing you'd expect of the court, and fundamentally compromising their independence and saying essentially, we are not an independent legal tribunal conducting legal analysis. We are an echo chamber and a rubber stamp for the General Assembly. Now, it gets even weirder because the ICC says, we're not even saying that they're actually a country. We're saying that they're a country for the purpose of joining the ICC. Now, it's a fudge. It's a little dishonest. There's no reason to believe that the word state in the Rome Statute, as in this treaty shall be open for membership by states, means anything different than what it means in any other international context of state, namely a country like any others. But if you want to play that game, one could say, why should we think that when the General Assembly voted to call the Palestinians a non-member state, they meant state in the sense of general state, or that they meant state in the sense of state for purposes of joining the ICC? They didn't say that. They could have meant that we're just calling them a state to, as an aspirational matter, which is probably very close to their intent. Certainly, it doesn't mean that they called them a state to say that they're a state for general purposes or for the specific purposes of the ICC. So really, it's bootstrapping, casuistry, and circular reasoning at its worst. And where do we end the day? We end the day, and I think the take-home message is, we're talking about international law, which is law that all countries are governed by. But in the end, we have a unique situation. There's no situation like it in the ICC, and there's no situation that will ever be again like it in the ICC, where a non-member state, Israel, is being investigated at the behest of a member, the Palestinian Authority, which is not a state. A non-member state being investigated at the behest of a member, which is not a state. That's a one-off, and this just shows that this is a unique procedure that has nothing to do with law, but simply with, I would call, judicially weaponizing the UN's lowest common denominator approach towards Israel. Thank you.
Thank you, Eugene, for these thoughts. Our next speaker is Anne Herzberg, who will speak about the legal status of some of the resolutions you've just mentioned and what this could mean for the potential blurring of the lines between law and politics. Anne, the floor is yours.
Great, thank you. So I'm going to focus on how non-binding UN resolutions and reports played the determinative role in the prosecutor's brief and in the pretrial chamber's decision, and they did so in three ways. Number one, as Eugene just mentioned, the court said that the UN General Assembly had the power to determine statehood for the purposes of joining the ICC. Number two, UN resolutions were relied upon to determine the territorial scope of the court's jurisdiction. And number three, UN resolutions and reports served as the basis for the prosecutor to determine that she had reasonable grounds that international crimes had been committed and she could open an investigation. Now, none of these bases are grounded in law and fact. But before I get into each of these three different aspects, I want to just recount a little bit of the procedural history. So in 2012, the former prosecutor, Luis Moreno Ocampo, issued a decision rejecting the Palestinians' 2009 attempt to join the court. But in rejecting this request, he also provided the Palestinians with a blueprint whereby the Palestinians could use the UN in order to effectuate an accession. And in his report, he stated, quote, "It is for the relevant bodies at the United Nations to make the legal determination whether Palestine qualifies as a state for the purpose of acceding to the Rome Statute." I also just want to add that, and we heard about Al-Haq from Yossi Cooper-Wasser, that Al-Haq and some other Palestinian NGOs have written about how during this period, they actively worked with the prosecutor and also the legal professor, William Shabas, who some of you may know, who had to leave the UN Human Rights Council Commission of Inquiry on the 2014 Gaza war for conflicts of interest with the PLO. He also at this time was primarily responsible for crafting this legal formula that the court has now adopted. So Ocampo puts this blueprint out in 2012. The Palestinians follow it to a T. First, they try to obtain UN member state status via the Security Council. That move is not successful. So they next turn to the UN General Assembly. And in December 2012, the GA passed Resolution 6719, which declared Palestine to be a non-member observer state and thereby enabled the Palestinians to join a whole host of international institutions and international treaties, the Rome Statute being one of them. And this is why we are having this discussion here today, actually. So now I'm going to get back to the three ways in which resolutions and reports factored into the court's decision. So first, the crux of the legal theory posited by the prosecutor was that determinations of statehood for purposes of joining the ICC can be made by the UNGA rather than looking at the definition of a state as commonly found in international law. And the pretrial chamber agreed. So in paragraph 97, the pretrial chamber wrote, "A determination by the UN General Assembly renders an entity capable to accede to the Rome Statute." Now, even though the wording of Resolution 6719 was aspirational, and many of the countries voting for this resolution at the time during the debates stated that they did not believe Palestine was a state. However, the way UN resolutions work, a lot of them are adopted by consensus. There's a lot of horse trading going on amongst countries. So a lot of the countries said, we don't really think they're a state at this time. However, we want to be supportive of the Palestinians. We want to be supportive of the peace process. And therefore, we're going to vote for this resolution. Nevertheless, the court found that merely a majority vote passing this resolution, non-binding political, was enough to prove competent for the Palestinians to join the court as a state party. And therefore, they did not do any additional legal analysis on that point. The second way in which resolutions factored into the decision was that the prosecutor in her brief exclusively relied on recommendations in non-binding UN resolutions, a whole host of them, and in reports by the Committee on the Inalienable Rights of the Palestinian People, a committee that was set up on the same day as the infamous Zionism is Racism resolution, to serve as the basis for defining the territorial scope of the court's jurisdiction. And again, the pretrial chamber agreed with this. the pretrial chamber took these resolutions as establishing legal facts, even though, again, they are not binding. And again, they did not provide any legal analysis as to how such non-legally binding political statements could bind the court's legal determinations. Now, it should be pointed out that a significant part of Judge Kovacs's defense focuses on these first 2 points, and I'm happy to say that he did incorporate some of the arguments in his analysis that I had raised in the amicus brief we had filed. He greatly criticizes the court's improper outsourcing of its competence determinations on jurisdiction to UN bodies. He also notes that the politicized nature of UN resolutions and that the wording of such resolutions are often that of recommendation, suggestion, or opinion, and cannot establish legal facts. And he also raised the point that many countries and a very slim majority of member states, even of the ICC, even voted for this resolution. Now, the third way in which the prosecutor relied on UN resolutions and reports, and these included the Commission of Inquiry reports from the UN Human Rights Council, was as evidence, in her opinion, that international crimes had been committed by Israelis on the so-called territory under the court's jurisdiction. Now, as Israelis, we love the expression shmum, which probably most of you know, but for those who don't, means, oh, who cares about the UN? This is a bunch of nonsense. Why do we even pay attention to this? However, I do want to mention going forward that UN resolutions and reports will continue to play a major, if not the most significant role in this ICC process. The prosecutor, and it's well documented, is clearly relying on unverified claims in UN reports as the basis for her allegations. And also, wearing my NGO monitor hat, I just have to add that when you unpack those reports, they're almost entirely based on unverified claims from NGOs, many of whom Yossi mentioned in his talk. And it will be very important going forward to speak out against and debunk the language, claims, methodology surrounding UN resolutions and reports. And it will also be important to challenge the admissibility of these reports anytime the prosecutor seeks to submit them as evidence. So I think I'll leave it there.
Thank you very much.
Thank you.
Very insightful. And our next speaker is our friend, Barrister Joshua Kern of 9 Bedford Row. Josh will speak a little bit about precedents and possible future ramifications that this decision may have on non-state parties and non-state actors. Josh, the floor is yours.
Thank you, Jonathan, and thank you for the invitation, and thank you to everybody who's joined. It's an incredible participation, so it's an honor to be here. Jonathan, your question is quite wide. To what extent are there precedents which might inform us now? Eugene, for example, has written extensively about the precedents that we could draw on with respect to the applicability of the Fourth Geneva Convention. And so I'm not going to touch on that kind of precedent in relation to the crimes or the alleged crimes themselves. I'm going to focus on the investigation of nationals of non-states parties and what precedents there is for that at the International Criminal Court as we move forward into this new investigation phase. We have 3 examples to date where the court has initiated an investigation in relation to the conduct of nationals of non-states parties. The first, we've already discussed or touched upon. Yossi mentioned the situation in Afghanistan, where the conduct of US nationals is being investigated. And I'm not going to touch much upon the Afghanistan investigation because it's the investigation that we're most familiar with. Instead, I want to focus more on the investigation of the situation in Georgia, where Russian nationals are under investigation at this moment in time, and also the investigation of the situation in so-called investigation in Bangladesh/Myanmar, in which nationals of the Union of Myanmar are being investigated, and they too are nationals of a non-state party. The Georgia investigation opened on the 27th of January 2016 and is relating to conduct which occurred during the August 2008 Russia-Georgia war. At that time, 2008, Russia was a signatory to the Rome Statute of the ICC, like Israel used to be a signatory to the Rome Statute of the ICC. Georgia was and continues to be a state party. Like Israel, Russia has unsigned the Rome Statute. Russia's unsignature took place in November 2016. So the situation in Georgia does bear some comparison with our situation because it engages the conduct of non-state party nationals, Russians, and it relates to an armed conflict on disputed territory, Skin Valley, as it is known in Georgian. The situation since the Russian withdrawal of its signature to the Rome Statute has, however, been notable for a lack of activity and a lack of noise surrounding the investigation. And indeed, there have been no substantial judicial pronouncements in the investigation at all since it opened in 2016. And the OTP has noted the difficulties that it has experienced in obtaining cooperation from Russia. We can't know at this stage whether this would be an obstacle to the investigation's progress to the arrest warrant stage. And also it remains to be seen whether the OTP would issue an arrest warrant against individuals in a situation associated with only one side to an international armed conflict. So we don't know yet whether the investigation or the OTP would consider itself competent to issue warrants in relation to Georgian nationals as nationals of a state party, but not to proceed against Russian nationals. For its part, the Georgian government is reportedly cooperating with the investigation. So what can we learn from the situation in Georgia? Well, one strategy that might appeal to supporters of Israel going forward would be to seek to adopt a Russian type strategy of deep silence before the court itself. Yet, given the intense international interest in our situation, a boycott of the court would seem to me to be a high-risk strategy, as the silence which marks the Georgian situation will inevitably be filled in our situation by not only the noise of pro-Palestinian activists, but also Israel's own core messages would risk being diluted, perhaps also by supporters of Israel, who may be advancing narratives and messages which are inconsistent with those of the state itself. Turning now to Myanmar. Myanmar's situation might be described as a tale of two strategies. The strategy it's adopted vis-a-vis the ICC and the strategy that it's adopted in relation to concurrent proceedings before the International Court of Justice. The ICC investigation opened in November 2019 and relates to a non-international armed conflict in the Rakhine state of the Union of Myanmar. Myanmar, for its part, has adopted a strategy of I quote, principled non-cooperation with the ICC. And the Union Minister for the Office of the State Councillor of Myanmar, Mr. U Kwa Tin Swe, said at the UN General Assembly's 74th session in September 2019 that he reaffirmed Myanmar's position on the jurisdiction of the ICC and noted that the investigation or the request for authorization of an investigation excludes alleged crimes by the Arakan Rohingya Salvation Army, which was a deliberate omission. Secondly, relies heavily on human rights reports that contain factual errors with regards to both international and Myanmar law, so echoing Anne's concerns there. Thirdly, mischaracterizes the criminal justice system of Myanmar. And fourthly, the Union Minister noted that the government's position remains that the court does not have jurisdiction over the alleged crimes in Myanmar. So these arguments may sound familiar to many of us on this call today. While such a strategy means that Myanmar is not—
We'll have now another like a minute, so if you can just wrap it up.
I'll have to skip the part relating to the International Court of Justice, but if anyone wants to ask about that in the questions, I'm sure they can. Just to conclude then in relation to Myanmar, while Myanmar's strategy before the court means that it's not legitimizing the proceedings through its participation, it's allowed a narrative of its own and its officials' criminal responsibility to predominate before the ICC. So what can we learn? We can observe that perhaps Myanmar has suffered from a lack of joined up and holistic thinking in its approach to communications before the court. Its advocates have failed to advance legal arguments which are available to it. And I can turn to this if anyone wishes to ask questions in the Q&A. The strategy which it adopted during the International Court of Justice proceedings has created several hostages to fortune for Myanmar, which may come back to bite it in the ICC investigation.
Thank you very much, Josh. We have discussed this before, so it's just important to mention that we are at the moment not at a stage of an investigation, and that it's up to the prosecutor to decide what to do. And we will have to see how this will play out in the future. Now our next speaker is Lieutenant Colonel in the Reserve, Maurice Hirsch. Maurice, you will address the Oslo Accords and their significance, and whether the majority view may have disregarded their true impact.
Thanks, Jonathan, and thanks for everyone participating, and thanks for the invitation to speak. The Oslo Accords. The Oslo Accords, in order to explain the Oslo Accords' relevance for the subject that we're discussing, we need to put in a few benchmarks, which obviously time limited, we cannot expand upon, but here they are in bullet points. A state, an independent state of Palestine has never existed, never existed. There was never such an institution, as Eugene quite correctly pointed out. They are not a state today. Why is that of cardinal importance for our subject? Because why is it that only states can join the ICC? It's because a state has inherently the jurisdiction to mete out justice, to have a criminal justice system. When that criminal justice system fails, that's when they can delegate their jurisdiction to the court. The ICC works on the basis of delegated jurisdiction. So if you have jurisdiction, you can then give that jurisdiction to the court. Since Palestine has never been a state, and this was really the fundamental problem with the majority decision, and they really skipped over this subject entirely. They assumed that since Palestine is a state because of the circular argument that Anne and Eugene pointed out, and since some type of opinions, reports, non-binding resolutions have decided that there are some Palestinian territories, well, so there must have been a state, and that state necessarily had jurisdiction to prosecute. That's just simply not the case. It's one of the major flaws of the decision. The Oslo Accords. The Oslo Accords are the only body of law, of substance, that gives any type of Palestinian entity any type of criminal jurisdiction. The Oslo Accords, as we all know, is a generic name for a succession of different agreements made between 1993 and 1995. In each one of the different agreements, there were common clauses that you see over and over again when preparing our submission, amicus submission for the court. I think I counted 17 different provisions in which the Oslo Accords made clear that the Palestinian Authority, this entity that was being created, would never have jurisdiction over Israelis. It didn't matter where the Israeli was. It could have been in the middle of Ramallah. The Palestinian Authority, that Palestinian entity that was created, has no jurisdiction over Israelis. And therefore, accordingly, it cannot delegate the jurisdiction that it never had to any other court. Now, we can see that this isn't only an Israeli argument, and the proof really is in the reality. In Palestinian Media Watch, we follow all of the statements of the Palestinian Authority, and there we saw time and time again, no other than the Palestinian Minister of Justice himself confirming that the Palestinian courts have never, in his words, prosecuted Israelis. They understood that they had no jurisdiction. What the Palestinian Minister of Justice understood was unfortunately missed entirely by the opinion of the majority, and it's something which really will come back to bite them, I hope, very seriously. Judge Kovacs, in his dissenting opinion, really hit the nail on the mark when he basically said that the only jurisdiction that could possibly arise to the court is jurisdiction regarding Palestinian actions, the actions of Palestinians committing crimes against humanity. For example, what the prosecutor herself had already mentioned previously as paying salaries to terrorists, really aiding and abetting, inciting, incentivizing and rewarding systematic attacks on Israel's civilian population by paying them salaries, shooting missiles. These are, according to the opinion of Judge Kovacs, one of the only places that the court could have possibly jurisdiction, really getting the idea that what the Palestinian Authority and what that Palestinian entity never had, they could now never pass over to the court, even in the constellation that they are seen as some type of state entity. Now, that really has to be taken into account. And again, the disastrous effect, which Judge Kovacs also pointed out in his decision of the majority decision, was it answered no questions. It said, you're a state, you have territories, but it never got into the full analysis of what would be the function of the investigation and what would be the outcome of claims made. For example, the claim that the Palestinian Authority never had jurisdiction over Israelis, has never tried to impose its jurisdiction over Israelis, and never prosecuted until this day any Israelis. That is something which I think is going to be a tremendous failure for any future proceedings in the court. Although I have to say, I have no false illusions about the court, in as far as we had, or at least I did, can't speak for anyone else, no illusions that the court would adopt the convoluted acrobatics of the prosecutor to invent the state of Palestine. So we believe that the real legal arguments that could and should and would have been made before the court and should have been accepted will have no relevance whatsoever. We are not talking about a legal decision. We are talking about a purely political decision that has no legal background and no legal validity, if truth be told.
Thank you very much, Maurice, for your thoughts. Our next speaker is Jonathan Turner, CEO of UK Lawyers for Israel, and Jonathan's presentation will focus on the Jewish and Israeli rights to the land that may play a major role in this proceeding.
Well, good evening, everyone, and thank you, Jonathan, for organising this important webinar together with the International Legal Forum. Just before I come to the specifics of that question, I want to say that this decision is not the beginning of the end, probably not even the end of the beginning. A long struggle is ahead of us. The decision is certainly not a victory for us, but we have opened up some cracks, both in terms of the weakness of the majority judgment and the strength of the dissent, which is a devastating critique of the majority judgment. I have practiced as an advocate for 40 years nearly, and I've won some and I've lost some, but no judge has ever said to me that my case had less than no legal basis, which Judge Kovacs told the majority. Anyway, the majority said that the state of Palestine must be deemed to exist for the purpose of the jurisdiction provisions of the Rome Statute, because the United Nations Secretary General had accepted a piece of paper signed by Mahmoud Abbas we suppose at any rate he signed it, saying that the state of Palestine exceeds the Rome Statute or something like that. The majority then relied on the Palestinian right to self-determination to support their assertion that the territory of that deemed state of Palestine extends to the whole of the Gaza Strip and the West Bank, including East Jerusalem. They completely ignored the existence of any right of self-determination or any other right of the Jewish people, or any other matter that might affect the boundaries of any deemed state of Palestine, such as, for example, the possibility that a majority of Arabs in Jerusalem may not actually want their city to be in a state of Palestine, according to some polls. Judge Kovacs forcibly criticized the majority's reasoning. He too did not refer to the rights of the Jewish people, at least not directly, but he did say that it could not be assumed that the Palestinian people are the reversionary sovereign entitled to any, let alone the whole of the West Bank and Gaza Strip, as defined by the 1949 armistice lines. He then identified a whole series of other possibilities, exemplified by numerous different situations around the world. And one of them, which I noted with interest, was recreation of a historically existing state annexed centuries ago by the other state. And let's have some audience participation. I'm inviting members of the audience who've not already looked it up to guess or display your knowledge by identifying the state that he was referring to in the chat. Now, while Judge Kovacs drew attention to these precedents in other situations, he did not make any points based on the specific rights of the State of Israel or the Jewish people, but we did make these points in our observations, and I think we should keep mentioning them in the course of the long struggle ahead. Firstly, under the doctrine of usi potestatis juris, which has been universally applied when new states emerge from the breakup of empires or federations or colonial rule, or most pertinently mandates, a new state inherits the boundaries of the previous administrative unit. In the case of Israel, on its independence in 1948, the previous unit was Western Palestine, which had been separated from Eastern Palestine by the Transjordan Memorandum of 1922 and subsequent independence of Transjordan in 1946. That separation established an eastern boundary of Western Palestine along the Jordan River and Arava Valley, even though, due to invasions by Transjordan and Egypt in 1948, Israel did not obtain possession of the West Bank and Gaza Strip until 1967. Secondly, under the mandate for Palestine approved by the Council of League of Nations pursuant to the resolutions of the San Remo Conference, the entirety of Western Palestine was allocated for the reconstitution of the Jewish national home. Now, this constituted some 3% of the Middle East territories of the former Turkish Empire that had been liberated in the First World War. The remaining 97% was allocated for the creation of future Arab states, now Syria, Lebanon, Jordan, Iraq, and part of Saudi Arabia. Arab leaders at the time were very pleased with this result. And in accordance with Article 80 of the United Nations Charter and advisory opinions of the International Court of Justice in the Southwest Africa and Namibia cases, the rights of the Jewish people under the mandate continued in force in the West Bank and the Gaza Strip following the departure of the mandatory power, Britain, in 1948. And sovereignty of a state of Palestine over these areas is incompatible with the rights of the Jewish people under the League of Nations mandate as continued by Article 80 of the United Nations Charter, without the agreement of the Jewish people or of the State of Israel as their legitimate representative. And furthermore, in accordance with Article 103 of the United Nations Charter and Article 30 of the Vienna Convention, those rights of the Jewish people take precedence over the Rome Statute and also over the Fourth Geneva Convention. These points are relevant to jurisdiction and also to substantive issues regarding the alleged crime of transferring population into occupied territory. And they should be raised whenever they're relevant. Jurisdiction can and should be challenged on these and other grounds whenever an Israeli is summoned or threatened with arrest. And they should also be invoked where relevant, to the substantive issues if we get that far.
Thank you very much, Jonathan. And I understand that Yifa, you also have some thoughts on these questions.
I have a lot of thoughts on many questions, but I'll be more specific. So first of all, I just want to tell everyone that we jointly, collectively as a network, have prepared many materials. I'm going to ask someone from my staff to put in the chat box a link to the website that we've put on. Many of you have contributed video, articles, different segments, information, summaries, so that if anyone wants to learn more about this, you're welcome to visit the website. So please see the address on the chat box. So I wanted to address the issue of self-determination. And so just so that people are clear, because I think a lot of people don't understand that the right to self-determination is in fact a very key right in today's international law. But that right to self-determination does not mean statehood independence, and certainly not some kind of a predetermined territory to that state. So just so you'd get a sense, if you just Google minority groups in Europe, just in Europe alone, you'll see that there are hundreds of minority groups just in Europe, ethnic, religious, national minority groups. They all enjoy the right to self-determination, although we know that they do not necessarily, even though some of them aspire to independence, they don't receive independence, because there are other issues at hand that goes beyond just that simple right to self-determination. And just to put things in context, I mean, people don't understand in essence that although we can all maybe agree to the fact that the Palestinians enjoy the right to self-determination, the fact that they don't have a state is because of many factors. And even though we see that there's a lot of sympathy in the international community, many of the players, the key players, the states in the world understand that the reason that the Palestinians don't have a state at this moment in time is because that they are bad actors. They're bad actors at this moment in time because they don't negotiate, they don't sign the peace treaties, they incite to violence, they encourage terrorism, they pay salaries to terrorists, et cetera. So basically, at the end of the day, even if we kind of visit these resolutions by the United Nations General Assembly and others, we always see that there's another a part to those resolutions. They keep on saying, even those countries that are sympathetic to the Palestinian cause, they keep on saying a Palestinian state can only be achieved, can only be accomplished via negotiations, via depending on their ability to recognize the state of Israel's right to exist, depending on their ability or desire to stop terrorism, to stop the violence, to negotiate. So when we talk about this, in essence, the right to self-determination, although important, as I said, does not mean independent sovereignty in a predetermined territory. So as I said, hundreds of minority groups in Europe, but not just in Europe. I mean, we all know of the Kurds. You know what? Let's talk about Europe just for a second. I mean, we see the struggle by the Irish, and we see the struggle by the Basques, and we see separatist groups coming out of Bavaria, Germany, and we've seen efforts coming out of Quebec in Canada. And there are a lot of groups, even famous groups, that do aspire for independence. But as I said, recognizing their right to self-determination does not mean that this equals, certainly not automatically. And even if a political entity like the United Nations have, given them some kind of an elevated observer status, in the United Nations, does not and should not, in terms of international law, predetermine the outcome that will now have potentially detrimental effects on on the world's order, let's say, even to that extent. Because if this is the message coming out of the ICC, I mean, you can pick up arms, you can deny recognition of other people's rights, you can blow up buses, you can bypass negotiations, you can do all those things. You can sign treaties and will just ignore those treaties that you've signed. all of that is lower in its importance to the fact that you have the right to self-determination, that I need, the audience today to understand how much that really changes not just international law, but even international order, and can potentially instigate, chaos and bloodshed to an extent that I don't think either of us can even imagine at this moment in time.
Thank you, Fa, for that passionate approach to the matter. I will now turn to Josh again, who will give us some thoughts on what would be the next steps and what could or could not happen.
Thank you, Jonathan. And this, I think, does pick up some of the questions that have been coming in the Q&A, which I've been trying to keep an eye on, but there are a lot.
Don't worry, Josh, I'm on them as well, and I will.
I'm sure you are, Jonathan. Thank you. But just to answer one of them, the pretrial chamber's decision is final. There is no appeal. Subject to the formal requirement to notify states parties and affected states that she has a reasonable basis to proceed with the investigation, the prosecutor can now rely on that decision in the course of the investigation. However, the temporal and procedural effect of the majority's decision is narrow. In other words, the decision is limited to the specific procedural stage when the investigation is initiated. And rights to make jurisdictional challenges, for example, but other challenges are also possible, are expressly preserved by the decision. But more technically, according to the majority, and this is paragraph 65, if anybody has the decision close to hand, the investigation was opened, quote, as a matter of law, as soon as the prosecutor decided to close the preliminary examination and announced that she believed that the conditions to open an investigation were met under Article 53. But that's not the end of it, because the OTP is obliged, a legal obligation under the Rome Statute, formally to notify affected states and all states parties, importantly, that the prosecutor has determined that there would be a reasonable basis to commence the investigation. On one view, the OTP's obligation to notify arose as soon as its reasonable basis to proceed crystallized, which one could argue was on or around the 22nd of December 2019 when the request was issued. Alternatively, the obligation to notify may have crystallized through the issuance of the pretrial chamber decision itself. In other words, the OTP's reasonable basis to proceed crystallized once the pretrial chamber confirmed the questions asked in the request on the 5th of February 2021. That seems to be the more reasonable interpretation of Article 18.1, given the prosecutor's admitted lack of certainty about territorial jurisdiction in December 2019, as well as her public statement responding to the PTC decision, which welcomed the clarity that the decision provided. In either case, we, my colleague, Dr. Dov Jacobs, who I work with closely on these matters, and I, are unaware of any actual notification that has been made to affected states and states parties pursuant to Article 18.1. The majority's decision, as well as Judge Brichambeau's separate opinion, also suggests that the notification procedure under Article 18 still must be completed. And on that basis, it seems that it may properly be argued that notice to affected states under Article 18.1 has yet to take place, and the investigation should not commence in earnest unless and until that procedural step has been fulfilled. And that's the step that Jonathan was describing earlier when he suggested that the investigation has not been launched. I would qualify that phrasing in a limited way, just to note that the investigation may, according to the majority, have been opened, but the obligation to notify has not yet been performed. And it bears emphasis that this notification may be made, as Jonathan rightly says, at an unknown point in the future, including, as suggested by the OTP, in relation to the Ukraine and Nigeria investigations, even after the appointment of a new prosecutor. And I'm sure there'll be some questions about that and the prosecutor election in the Q&A. Just a word of caution, if I may, Jonathan, before I conclude. We would caution against putting too much emphasis on the requirement for an Article 18 notification, given that we suspect that Israel is not likely to utilize the procedure. To insist on Israel's behalf on the application of a formal requirement of the Rome Statute, in the suspicion that the procedural avenue will not be utilized, risks creating a perception of bad faith that will be seized upon by those who stand opposed to us. And such a challenge may then be better framed by a friendly state party who will also have a legitimate expectation that they will receive a formal notification from the OTP pursuant to Article 18.1. And those are the next steps as I and Dr. Jacobs see them.
Many questions speak about strategy with regard to legal and public diplomacy efforts. So I'd like you very experienced in this field. So I'm happy to, if you can take that.
Well, the straightforward thing would have been to file an appeal, because this is supposed to be a legal decision, even though I don't believe it to be a legal decision. But the straightforward thing would be to file an appeal. However, the state of Israel, as you all know, have made a conscious decision, a well thought of decision, not to participate in these proceedings at all and not to legitimize the authority of the court. I don't anticipate that changing, especially not after the court has actually now proved the fact that they are a political entity and not really going to rely on international law to make their decision. So the option of appeal, I believe, is off the table. Other things that we thought that we are able to do, I think we all had ideas here, and they are ideas because there are different fundamental problems, as we all pointed out, with this decision that we can all choose to stress. We can choose to stress, the political element. We can choose to stress, the various flaws in this decision. We can choose to stress the identity of the judges or the prosecutor. We can choose to stress, the various NGOs that contributed significantly to these proceedings and their affiliation with terrorist organizations. We can choose to stress the fact that the PA is a bad actor, not just Hamas, by the way. I keep on hearing Hamas. We all know Hamas is a bad actor. It's a terrorist organization. What we don't know, and I think many people don't know, and we should stress, is the fact that the PA itself is a bad actor. The PA itself funds terrorism. The PA itself incites hatred and violence and murder. There are many ways for each and every single one of us to contribute. We can be active on social media. We can write letters. Whether you're a lawyer or not, you can make the case in a simple way. You can, we can sit and write legal briefs. We can make videos to use on social media. I think we all should be very active on this because, as I said, I think numerous times, it is beyond outrageous. Jonathan?
Yeah, so thank you, Yifa. We have to wrap up. Friends, this has been an exciting event. Thank you to all of our speakers and also to all of our participants for taking the time to discuss this important matter. Israel, the Palestinians, and the ICC, I'm certain that this topic will continue to be relevant to us, and therefore it's so important to follow closely and remain engaged.
Jonathan, before you wrap up, I want to remind everyone that we have this website where you can find a lot of materials. There are over a dozen videos of the various experts. Many of them are here today that you can learn from and you can share. Also on our website, the International Legal Forum, there are a lot of materials. And I urge every single one of you, if you have questions, if you want more materials, if your questions were not asked, if you need help, guidance, anything, email us, call us. I mean, this is what we're here for. We want to do this together. This is important. And please feel free to contact us at any moment in time.
Yeah, this would have been exactly my next point. Of course, Yifa and her team, and also our team at the ministry, of course, at your service at any time. Thank you, Yifa, for your help in setting up this event. To everyone, thank you for all you're doing for Israel and the Jewish people. And stay healthy, stay safe, and Shabbat Shalom. Thank you very much.